Magdelyn Matius. Today I will discuss the legal principles regarding painting and sculptures in the sales of the Victorian style property that Abraham purchased from Brenda. We will cover 4 key points, which are the law on fitting and fixtures, the law applications to Abraham's situations, the importance of the item to the property value, the challenges that Abraham might face, and a possible outcome. The issue in this situation is whether the painting and sculpture are fitting or fixtures. In a leading case, Holland and Hodgson's Blackburn J said that the general principle is a quid pro quo solo credit, which means whatever is attached to the land to become part of the land itself. This was the general maxims of the law. Meanwhile, fitting means chattels that are physically in the property and in some cases attached to it but not considered to be part of it. Under Section 62 of the Law of Property Act 1935, any fixtures will automatically pass to the purchaser. Fitting could include items like freestanding furniture and appliances, kitchenwares, pictures, and hanging mirrors, while fixtures could include kitchen units, worktop, carpet, doors, and bathroom suite, as well as the boiler and the heating system. Why would fitting and fixtures matter? This is due to the fact that in order to prevent disagreement, parties ought to be cautious when defining what will be left over and what is covered by the purchase price in the sales as soon as possible. Problems may occur when a tenant uses a break clause in their lease. If the tenant doesn't take out everything, they might not have followed the terms of the break clause, which could leave them stuck in their agreements or lead to a conflict with their landlord. The development of the case law has led to the conclusions there are 2 main tests to apply to determine whether an item is fitting or fixtures. The tests are the degree of annexations and the purpose of annexations. The annexation test established by Blackburn J in Holland and Hodgson's holds that an item that is only loosely attached to the land is deemed to be part of the land unless intended use was as a fitting. The test inquiry as to whether the fitting was affixed to the property or for ease of use or a greater enjoyment. Stones stacked in a builder yard would remain as a fitting, but block or stones placed without cement or mortar would become part of the land. In Holland and Hodgson's, a mill owner purchased loom and had them nailed to the stone floor, but the mill was repossessed due to the mortgage failure. The court ruled that the loom remained as a fitting. In Land and Tellers, a very valuable tapestry attached by tack to strips of wooden frames was held not to be a fixture because the purpose of attachment to the building was never intended to become part of the property. While in Ham and Grave, the seller removed several items from the property, but the purchaser argued they were fixtures and should remain at the property. These included the petrol lights, urns that were attached to the wall with screw, a Chinese ornament, statues, clean and a lid through all of which were resting on their weight. The court decided that the annexation's goal was crucial. However, the degree of annexations of an item was the primary concern in early legal cases. The purpose of annexations have become more important to the point where it is the main consideration and is therefore the dominant factor in deciding whether an item is fitting or fixtures. In D. N. Court and Gregory, The court ruled that the stone statues, tapestries, and other objects affixed to the wall were fixtures, as they become the integral part of the garden and could not be removed. In Rio Valley, the tapestries and portraits were considered fixtures as they were part of the overall architecture designs of the room. In Barclay and Portland, the court ruled that the cellar possessions, including a half-tone marble statue, sundial, and pictures, were not fixtures but fitting, as they were not considered as a fixtures by Court of Appeal. In the additional case of Botham and TSB Bank, the Court of Appeal had to decide whether the 109 distinct items in a property were part of the security of a loan. This could have been the case if the items were fixtures. 9 categories were assigned to the items, 8 of which were in dispute. To the general ideas of the approach used, it is not necessary to list every item. Fitted carpets, light fixtures, gas fire, kitchen appliances, and bathroom fixtures like soap dishes, towel rails, and the toilet roller were the most important items. Abraham's case revolves around whether the painting and sculptures are fixtures or not. In order to determine whether it's fixtures or fitting, the court will consider the purpose of the annexations. In this regard, the parties' choice of language regarding a specific object is not determinative. While it is generally true that an item will not be regarded as a fixture unless it physically attached to the land, that alone is insufficient. The court will take the case objectively. The taste for fixtures depends on whether the statue is physically fixed to the land or it was placed on the property. In this case, the painting and sculptures are not fixtures. In Barclay and Portland, a marble statue of a Greek athlete was not considered as a fixture. However, the general rule can be applied when the object of annexation is foreshadowed to become part of the land as seen in Holland and Hodgson. Scammon law justice support this view, stating that annexation may not prove anything if the object purpose is for enjoyment. However, affixations cannot be ignored if the object cannot be removed without a serious damage or destructions. Roche law justice ruled that temporary attachments are shadows, while permanent items become fixtures if they enhance the building. Despite being ornament objects, statues may not necessarily to be intended to become part of the land. In Rio Valley, shadows were considered fixtures when used to create Elizabeth room, as they were held to be part of the general architecture design of the room. In D. Encott and Gregory, statues in architecture design were considered fixtures. Painting and sculptures that significantly enhance the room aesthetic and value are considered fixtures. However, Brenda's statement about discussing further if he sealed the deal immediately could create ambiguity, potentially leading to a misrepresentations in a contract. In these situations, Abraham would face challenges in proving that the painting and sculptures were fixtures. Abraham could still pursue to take legal actions against Brenda. The court may rule based on the establishment principles of fixtures and fitting. However, that will make it difficult for Abraham to prove that the painting and sculptures are fixtures. In conclusions, the painting and sculptures are fixtures. This is because the degree and purpose of annexations based on the placement and significance of these items, which are to enhance the property aesthetic. This could be referred to the case of Rio Valley, where fitting are considered fixtures when they are used to create Elizabeth room. In D. Encott and Gregory, the statues in architectural design were considered fixtures. This shows that the degree and purpose of annexations are fully fulfilled as a fictitious. That's all from me. Thank you.